Hi, welcome to Cona's Corner. I'm Jennifer Cona. This is where we answer your questions so that elder law and trust and estate mistakes don't happen to you. Today's question is, I want to protect assets with a trust, but the attorney also wants me to sign a healthcare proxy, living will, and power of attorney. That is adding to the cost. Do I really need to have those documents? Wow. Okay, so my first reaction to this is don't be penny wise, pound foolish. So a healthcare proxy, power of attorney, and living will are what we call advance directives, and they are critically important for anyone 18 and over. A power of attorney is where you designate someone to make decisions of a financial nature. A healthcare proxy is where you designate someone to make healthcare decisions for you and to be your voice. And a living will is where you set out your wishes regarding end-of-life care. They are really important so that your wishes are followed, so that you're making your decisions now and someone can help carry them out for you later. So you don't want to not have your wishes known, and you don't want to have them not documented, because that's how they get followed. So that's why they're super important. So we had a client who came to us and had a similar feeling, in all honesty. Wanted to do the asset protection trust because that was the most pressing thing on their mind. They wanted to protect their house, which was their most valuable asset. So they put their house in the trust, saving $1 million asset, and didn't want to do the advance directives, which of course we advised them against because it's super important. But they insisted they didn't want to do that. So we made them sign off that it was against our advice, but they left without doing that. Sometime later, I think it was about 1.5 years later, that person had a stroke and went to a hospital and then a nursing home. Well, they had assets outside of the trust. I think they had another couple $1 million, if I remember correctly, that was in bank accounts and investment accounts. So that money was not protected. And without a power of attorney, they had no one in the family or elsewhere who could access that money and make asset transfers to start protecting that money, or do the crisis planning to start a promissory note and protect those assets from the cost of the nursing home care that our client then needed. So that money was now subject to being spent down on the cost of our client's care. Now, if they had a power of attorney, that person could have accessed that money immediately and done the crisis planning. So we were then facing either the loss of that money or a guardianship proceeding, which takes a lot of time, a lot of money. It's a full court proceeding. It's just not a position that you want to find yourself in. We didn't want to find our client in this position. It was a terrible situation, and it could have been so easily been prevented by our client signing the advance directives at the time we were doing the other work. It was just the worst case scenario, and I would never want it to happen to anyone. So that's the takeaway. Don't be penny wise, pound foolish. There's a reason that attorneys like myself will give you advice. Follow our advice. That's what you're paying us for. So I hope this information was helpful to you. Please like, share, and subscribe, and we'll see you next time.